David Barker, I'm going to be chairing the subcommittee meeting this morning. To my left and right are the members of the committee who will introduce themselves.
Councillor Drabble. Maroof, Raouf, Sheffield.
And you will see a number of other people sitting around the room who are working with us this morning. Would you like to introduce yourselves, please?
Morning, Samantha Bond, Legal Advisor to the subcommittee.
John Cooper, Democratic Services.
And I'm Jane Goff from Licensing to read the report.
And could you confirm your names, please, for the record?
Morning, Chair. Alex Green, Gostrok Solicitors, on behalf of the applicant.
Good morning, my name is Pav Sharma. I'm a Regional Manager for Stonegate.
Brilliant. And you've already sussed out the microphones, which is good because I still haven't after all this time. So, I'm sure you'll be aware we have a set process for these hearings, and you'll also be pleased to know that item 4 of that process, to save me having to read out loud in public, it says the solicitor to the committee will outline the procedure. So, Sam, could you outline the procedure, please?
Thank you, Chair. Have you got a copy of the papers to hand that you can see? I've got some extras if you need. So the procedure is just right at the back of the pack. It looks a lot worse than it is, but I'll just quickly run through it. So the licensing officer, who's Jane this morning, will introduce the report. If there are any questions concerning the report, that could be raised then, just so we can get that amended and reflected in the record. There are no representations outstanding from the responsible authorities. The interested parties, local residents, have been invited to the hearing, but I think some have said they can't attend, and others, obviously, as you can see, haven't attended today. So what we'll do, we'll head straight over to you guys just to detail the application, provide clarification on the application and respond to the representations made within the report. There'll be an opportunity for members and officers to ask questions. You'll then be given the opportunity to sum up the application, just to leave us with any final thoughts before we take the options from the licensing officer. We'll then ask you to just wait in the other room while we go into private session so that members can take legal advice and consider the application. The decision of the licensing committee will be given in accordance with the requirements of the Licensing Act 2003 and regulations made thereunder. Any time during the hearing, members can request legal advice, so we can either do that in open session as we are now, or private, again, where we will just ask you to wait next door, and then we'll invite you back in and feedback what was discussed. And it is an open public hearing this morning that is being live webcast, and there are rules and regulations surrounding the webcast that can be found on our website if needed. That should be everything. Thank you, Chair.
Thank you, Sam. So, could we have the report then, please, Jane? Does anybody have any interest to declare in this? You're going to make a fortune out of this, aren't you, Mark?
One day.
One day. No interest to declare.
Okay, good morning everybody. Thank you for coming this morning for the licensing subcommittee to determine the grant application for the Anvil Inn on Stannington Road, which was an application submitted on the 22nd of August 24 to the licensing service, following information being received that the previous company which held the licence had been dissolved and the licence had lapsed. Therefore, this grant application has been described as a relicensing exercise more than a brand new application, pretty much putting like for like back in place to what was there before. So we've had some local residents that have objected against this, which are at Appendix B in the report. They have all been invited to attend, but none of them have been able to attend or have responded, one or the other. During the consultation period, the applicant have agreed conditions with the Environmental Protection Service, Sheffield Children's Safeguarding Partnership and South Yorkshire Police. All these agreed conditions can be found in Appendix C of the report. So I'm going to scoot through the rest of the report so that we're not sat here for ages. So down to Section 8, to the appeal section, which states that the Licensing Act 2003, Section 181 and Schedule 5 makes provision for appeals to be made by the applicant and those making representations against decisions of the licensing authority to the Magistrates' Court. So the recommendations this morning, Chair, are that members carefully consider the representations made and take such steps as the subcommittee consider appropriate for the promotion of the licensing objectives.
Thank you, Jane. Do members have any questions on the report at all? I've just got one question sort of vaguely related to the report, obviously because it's a relicensing. And I just wonder, did licensing receive any complaints regarding the previous licence?
We've got 3 complaints on file. 2 are old, like more than 4 or 5 years old. Let me just go back into the system. One was from last year. Bear with me, my system doesn't want to play ball. So this was from June 23 from a member of the public advising about public nuisance in the car park of the premises, stating that there was concerns about groups of youths in the car park taking the nitrous oxide balloons over a weekend in June, but that's the only thing that's on file of recent years.
Thank you, Jane. Have the applicants got any questions regarding the report?
No questions. I'll cover everything in my submissions, Chair, if that's okay.
Excellent. Then over to you for your submissions.
Thank you, Chair. Good morning, everybody. Apologies again for being late. I'll try and be as brief as possible today. If it's okay with the committee, I'll go through my submissions in 3 stages. One, I will explain, obviously, why we're here today. Obviously, we heard from Jane about that. 2, I'll demonstrate how the application promotes the licensing objectives. And then finally, I'll respond to the representations received. So, the applicant, EI Group Limited, part of the enormous Stonegate pub company with over 4,000 pubs in the UK, over 17 Sheffield alone. The vast majority of these are tenanted, i.e. run by independent people who operate under a lease agreement, and the tenant would usually hold the premises licence in their name. Unbeknown to my client in the summer, the tenant who went into administration, insolvency, etc. This should have been reported back to my client by the tenant under the terms of their lease, so that a simple premises licence transfer application could have been submitted. It wasn't, and because of that, the premises licence lapsed. Here we are today. Once it became clear what had happened and what needed to happen, my client quickly submitted an application for a virtually identical premises licence to rectify the administrative error that had been made. It was important that the application was identical when it came to the core areas such as alcohol and opening hours, as we wanted to demonstrate that we were simply relicensing reopening as before. This is a nice community pub with no real history of problems at all. So, the licensing objectives, how are they promoted? Well, as part of this application, we updated the conditions that were on the previous lapsed licence, and we also quickly agreed even more comprehensive additional conditions with the EHO, the police, and children's safeguarding. These include comprehensive CCTV, staff training on alcohol dispersal, vulnerability, etc., etc., incident refusal book, strict Challenge 25 operation, signs to advise customers as they leave about noise and nuisance, zero tolerance policy on drugs, the use of SIA door staff to be risk assessed by the DPS and the premises licence holder, all windows, doors to be closed when regulated entertainment is on, no amplified music outside above background levels, outside area not to be used after 11 PM, save for smokers, no drinks allowed outside at that time, staff to make checks outside to monitor any outside noise to ensure no disruption to local residences. So, lastly, Chair, onto the representations. Well, I'd ask you to consider the representations against the backdrop of the fact that there are no representations whatsoever from any of the responsible authorities. I'd also like to point out that the single objection letter received in your packs has a number of names added at the bottom. I think it was a kind of petition your neighbour friend situation on that. Also, what was very clear from the objection letter is that there was a clear misconception as to what was being applied for. The residents, it seems, falsely believed this was some form of variation application to try and extend to get really late hours. Obviously it wasn't. I did communicate through Jane and the colleagues with the residents via the licensing authority to explain we're simply relicensing the pub with exactly the same hours and everything as before. I hope and think that helped to reassure them. It is also important to realise that there is a new and extremely experienced tenant at the pub now ready to run the pub going forward. So very quickly looking at some of the quotes in the representation letter. We object to the Anvil applying to extend their opening hours and the location of the pub in a residential area. Well, as I keep saying, all we've done is replicate the existing lapse licence hours, so there's no extension whatsoever. And the pub is an old building that has been there, I believe, since the early 1900s. It's not a new pub in an established residential area. Issues with loud noise, external live music outdoors. Well, we've agreed conditions with the EHO, as discussed before. They will prevent any noise nuisance happening, no amplified outside music, doors and windows closed, etc. People outside in the garden, we can only assume this will go on till even later. Well, again, the hours are not going to be later, and a new condition has been agreed anyway, that customers cannot use the outside areas after 11 p.m. unless they're smoking, but no drinks will be allowed out there anyway at that stage. I've whisked through everything as quick as I can, Chair. Those are my submissions. Thank you.
Thank you, that's excellent. I'll open this up for questions then now. Maroof, would you like to start us off?
I don't have any question at this moment in time, but I might come back later. Thank you.
Mike, is there anything you'd like to ask?
Thank you, Chairman. Thank you for coming, gentlemen. I suppose, perhaps you could enlighten me about the relationship between yourselves and the tenants, because I'm wondering where the responsibility lies if, let's say, some of the conditions you've talked about, the additional conditions, aren't being adhered to. Would that be the tenant would be expected to kind of address those, or would you have any input as a group?
Oh, it's a good question, Councillor. I'll jump in, and if Pav wants to add anything on an operational basis, I'll ask Pav as well. It's a kind of two-pronged thing, really. The tenants, once the tenant is in and established, obviously there's a big vetting situation with these tenants. They're not just thrown in. The new tenant has been in the industry for 20 to 30 years, for example. So the premises licence will be in the tenant's name. So they are the premises licence holder, and then invariably will be the DPS as well. So responsibility lies with them. However, a massive pub company like this doesn't have risk on their building, their premises, their property, and just allow anything to happen. There are checks and measures, there are detailed clauses, and I used to be a commercial property lawyer, so I'm not going to bore you with it, but there are lots of leases, lots of clauses in the lease for the tenant that means they have to do X, Y, Z, and if this happens, they have to do this, this, and this, they have to report back, they have to... So usually there are strict controls, there are checks, there are measures, and obviously with regional managers like Pav, they regularly visit and they check on everything as well. Pav, is there anything else you'd like to add?
No, I think you've covered it all. They see me on a regular basis. I'm part of that. We review things with them on a monthly basis. So no, nothing more to add. Thank you.
Thank you, Jeff. Thank you for your answers, gentlemen. So I suppose what you're describing then is there's a regular process in which you're checking up on the people who are managing those pubs, the tenants or whoever. How regular is that process? I mean, how often do you check?
So officially, I think we have to go back once every 12 weeks. That's part and parcel of the job. However, anyone new that goes into the business, we would see them probably. So I've seen the publicans on a weekly basis, and to start with, as they're going up, we will see them probably. I will see them once every month, or if they are new in terms of new publicans, it'll be weekly until they're established and up and running. But our requirement is a minimum of once every 12 weeks.
Thank you. And so, you know, from what you're saying, you're suggesting you think you have a fairly robust process for kind of managing this. How many times? Well, I'm not expecting you to come with a precise figure because you probably don't have it. But roughly in the last 5 years, can you recall any times when you as a group have had to remove a licence from a licensee? I mean, have these teeth ever been bared, as it were?
Well, I'll jump in very quickly. As far as the question, how many times have we had to do a relicense like this? Unfortunately, it does happen occasionally, but I think that wasn't what you're asking. But yeah, I mean, as far as removing tenants are concerned, well, the estate has been between 4,000 and 5,000 strong. Unfortunately, pubs are closing. So it used to be nearly 6,000 in this estate. I think it's now down over 4,000. As far as in a number like that, occasionally there will be, I guess, the odd bad apple, like anything in life. There'll be occasionally, if they breach the terms of their lease, if they don't pay the rents, if they do this and they breach their terms of their licence, and anything happens, then yes, there are procedures in place for the freehold owner and the landlord to get rid of people. Absolutely, they can't just be allowed to run amok, shall we say, Councillor.
Thank you. And obviously I realise I wouldn't expect you to pull those sorts of figures out there, yeah, well, that would be very impressive. So I suppose I'll go to yourself as Amelia. How long have you been with the group in this position?
Just short of 7 years.
7 years. So have you ever had to occasion to remove a licensee for you know, non-performance or similar reasons?
Absolutely. Unfortunately, as we've discussed, we do get a few bad apples. If a publican ever endangers the licence at all, we then remove them. So we can serve notice on them. I've had to do it probably 3 or 4 times where we've had publicans that have not committed to the agreement, the tie that we've set with them in accordance to our lease, or if they've ever if there's been any risk to any licence. So throughout the different geographies I've looked after, the last one I did, I think, was in Pontefract in just outside of Leeds. We removed the publican out of there just because they were not adhering to what they said.
Thank you. Just a final question on a slightly different subject. You know, you make the point that this is, you know, an existing pub that's been there decades and is, you know, kind of a fixture in the community. And hence you're applying for a re-licensing because, you know, not much in your opinion has changed. However, we know that in that part of Sheffield and in many other areas surrounding Sheffield, new houses are being built over time. You know, new houses are coming up all the time. I mean, you know, I'm just wondering if you were kind of in a new house with one house. Well, let's imagine yourselves, fellas. You know, I mean, I'm sure you live in kind of big detached houses with extensive grounds and all that. But you know, if you were living near here, I mean, near this pub, either in new build or in one of the places that's houses that are there already, would you be satisfied with having this licence, or would you be objecting?
Well, it's a good question, Councillor. Would I be objecting, or would I appreciate and use the good local community pub as a great thing in the area? Then yes, I'd use it as a local community pub. If I was being disturbed on a regular basis, if there were lots of complaints, if there were lots of issues, if there was a massive problem pub in the community, absolutely would I object, 100%. This isn't a review, Councillor. You know, there have been no issues here. I mean, a couple of people have mentioned that a couple of issues over the car park over the last few years. We've heard from Jane one complaint in the last 4 or 5 years. This isn't a problem premise, and the people that are coming in are very, very experienced people running the pub. So I'd be using the pub. If there was a problem, I would be complaining to the EHO, I'd be complaining to the police, I'd be doing everything through the normal channels. That hasn't been happening here, and it certainly won't be happening going forward, Councillor.
Thank you for your answers, gentlemen. Thank you, Chair.
Just a couple of things from me. You said on a couple of occasions you've got a very experienced tenant coming in. I just wonder if you could tell me a little bit more about the experience of that tenant.
Yes, so the 2 publicans, they live very local, so they are within a stone's throw from the pub, so they know the pub. We've got Leslie, who has over 30 years of experience, heart of the community. Everyone loves Leslie. They've come in there, and their view is this pub should be a more family-run pub. They've spent some money decorating. They've used this time to decorate the pub to make it more. They've made it more. I'll use their words, lady-friendly. So it's now the weekend. They've had lots of women in there as well as the men. They come in as couples. They have a great background. The other publican has just passed her own personal licence last week, just applying for her own licence as well. It's just very professional people that want this pub that they live very local to kind of work. So you know they're very local and very knowledgeable about the industry.
Thank you. I think probably just finally from me, you've got lots of things in place that should actually control the issues that are being raised by the interested parties. I just wonder if there was an issue, is there a means to contact someone to have that addressed, or would there have to be a subsequent complaint? You know, if a neighbour was being disturbed by noise, would they be able to contact the pub immediately and get an immediate response to that?
Well, I'll just jump in very quickly there, Chair. As always is the case, if somebody has a complaint, I would always suggest respectfully that they attend the premises and speak to the manager, speak to the tenant, and put the complaint through those channels initially. Obviously, if they keep doing that, and they were getting nowhere, then obviously there'd have to be some form of escalation. They'd have to maybe go to the authorities. But I would expect in this situation that if somebody did have a small issue, just to pop down the road and have a quick chat and over a coffee and remedy the situation.
Thank you.
Thank you. Just a couple of quick questions. Just like you to turn to page 34 of the report. It says Anvil conditions. I just want to check, are those conditions that you are looking to move forward with?
Sorry, which...
Page 34.
I've not got page numbers. What's the heading? Sorry, Councillor.
It says Anvil conditions.
Last page before the
Yeah, they were the conditions, they were the initial conditions put forward, and then the conditions that follow are the ones that were agreed with the police and in EHO and everybody else. So they're all together.
No problem, that's fine. I just want to check a couple of things, especially on number 2. Could you just explain the discrepancy as to why you originally went with a Challenge 21 age verification policy and now have agreed to a Challenge 25?
Well, it depends. Good question, Councillor. Because it's a tenanted pub, you always have a challenge in place. You always have a challenge, at least 21. We do a lot of supermarket work, and because of the nature of supermarkets, you have families, you have kids, it's Challenge 25. Challenge 25 is very common throughout the industry. On this situation, initially, because it's a tenanted pub, we put forward Challenge 21. Obviously, it would have been up to the tenant. The tenant would have probably changed it to Challenge 25 anyway, and it was quickly changed to Challenge 25 anyway by one of the responsible authorities. Challenge 25 is usually the norm.
Okay, so, I mean, I'm not sure my question is actually being answered, so I'll repeat the question again. Why did you originally go with the Challenge 21 and have now agreed to a Challenge 25?
Because the tenants, we weren't sure, obviously, with it being a tenanted pub, and some tenants run a Challenge 21, some tenants run a Challenge 25. I say tenants, publicans. Some publicans throughout the country will run a Challenge 21. But across the board, as you say, you're right, Challenge 25 is the norm, and that was quickly offered up. There's no issue, we have Challenge 25 everywhere.
Okay, no problem, thank you. And just the other one about part number 6, no customers shall be admitted to the premises at any time carrying open bottles. And number 7, how do you plan on enforcing that?
Well, that'll just be run by the management. I'll ask Pav if there's anything in particular, but as far as running anything in the pub is concerned, the staff, the management, the DPS, as they would enforce everything within the pub, they would enforce that as well. If people rock up to the front of the pub carrying a beer glass or a bottle open, they'll be ejected from the pub and not allowed in. Okay,
what about number 7, allowing people to go outside of the premises with open drinks or open containers?
Again, Councillor, you know, it's a standard condition. People aren't allowed to basically take their drinks away with them and walk down the street. It's in virtually every pub licence. It's a standard condition.
I mean, the question is, how would you stop somebody from doing that?
Again, same as the last question. By the staff, by anybody just watching, by the staff, by the management, running a tight ship, the comprehensive CCTV, etc., etc.
No problem. Thank you. No further questions.
Sam, is there anything you'd like to ask?
Nothing major, just to clarify, it was Stonegate owned previously, the pub?
Yeah, the pub's been open for, the pub's been run by Stonegate for nearly 20 years. I say Stonegate in its different guises, Enterprise Inns, EI Group Limited, etc. Yeah, but sort of comes under the Stonegate umbrella. I was going to ask how long you'd run it for, so quite a length of time. And I think, as you said before, the pub itself has been there since the 1900s. I believe so, early 1900s.
Yeah. No, that's all from me. Thank you.
No further questions. Would you like to sum up your application?
Thank you, Chair. So I'll quickly sum up what we've heard today. Section 9.43 of the Section 182 Home Office Guidance states that an authority's determination should be evidence-based, something that was already highlighted in the well-known High Court case of Thwaites. So what is the evidence? Well, no objections or concerns from the experts and the primary sources of guidance in crime and disorder and noise and nuisance, i.e. the police and the environmental health. In fact, out of all the residential properties in the wider area, there was only, in effect, one objection letter, and that was mainly because they misunderstood what was being applied for. Surely, if this was a problem pub in a problem area, the police and others would have objected. This fact should carry considerable weight when determining this application, in my humble opinion. As we've already seen, the robust comprehensive conditions in our application, which incorporate the additional ones requested by the responsible authorities, demonstrate how seriously my client takes the issue and the risk of crime and disorder, protection of children and noise and nuisance. We have a very experienced tenant who wants to revive this well-established community pub in a lovely old building and maintain its place in the heart of the community. They've even opened the pub for a few weeks under temporary event notices, and they've been very successful and welcomed by the locals with no issues or complaints whatsoever. So I'll finish by reminding the committee it's not a review hearing. In fact, we would not be sat here today if somebody had simply filled out a form, a premises licence transfer form when they should have, if they'd have known about it. I conclude by thanking the committee for its time, and in light of what we've heard today, I invite the committee to grant the application and give the community their pub back. Thank you.
Thank you. Could we have the options then, please, Jane?
You certainly can. So the options available to the committee this morning are to grant the premises licence in the terms requested, to grant the premises licence with conditions, or to reject the whole or part of the application.
Thank you. Could I ask you to now leave the room with the licensing officer while we take some legal advice, and as soon as we've come to a decision, we'll invite you back in. Oh, welcome back, and thank you for your time and your representations this morning. The decision of the licensing subcommittee today is to grant as applied for. In granting, I will say for the benefit of any of the objectors who may be watching or may watch the webcast later, obviously granting today doesn't mean that the licence is granted in this form forever. If there are problems, obviously you and the tenant have given a willingness to try and address those concerns. But if they can't be addressed, then a review of the licence can be requested at any time, and we can take whatever action is necessary to control those issues. I really hope that will not be necessary, that you'll have to dash upon a poor train service to Sheffield to address those concerns. And I hope it runs for many more years as a successful community pub. So thank you for your time and for your attendance this morning. Thanks.
Thank you. Again, sorry, just for the benefit of the recording, the interested parties do have the right of appeal against this decision. So everyone will be receiving a determination notice following this hearing, setting out what members considered, how they came to the decision, and just confirming all the conditions that will be going on the licence. So should any interested party wish to lodge an appeal, that's within 21 days to the Magistrates Court. Really appreciate you coming today, and thank you very much for your time. Thank you.